Mr. Vetter, if you want to go ahead and unmute your device and start your audio. Good morning, Mr. Vetter. In the matter of the people of the state of Michigan versus John Edward Vetter, file number 21-20353FH. Mr. Vetter, you've been in compliance and Mr. Stevenson is dismissing the violation of probation, all right?
All right, thank you.
Thank you. Have a good day.
Yep.
Thank you. Just admitted somebody on a Samsung device. Could I have your name, please?
Trying to get Jamie Stocks. Jamie Heimerdinger.
All right, thank you. I'm gonna change your name. Who's your attorney?
Miss Anderson.
You mean Miss Underwood?
Yes, I'm sorry. I always mix that
It's
up.
okay. It's all right. All right, so I'm gonna change your screen name. I'm gonna pop you in the waiting room. When she gets here, I'll
Okay.
bring you back in, okay? All right, Miss Adams, I'm gonna send you a chat.
Okay.
Okay. Mr. Goldstein, are you here for Zachary Rosenberg?
Good morning, Your Honor.
Hi,
Yes,
I'm
Your
sorry.
No worries.
Hold on one second. You said yes, Mr. Goldstein?
Yes, Your Honor.
Okay, I'm ready for Zachary Rosenberg.
Yes, ma'am.
All right, thank you.
Yep.
Other stuff is fine. All right, so I called your client. Discussion, Tindle is Rhonda Underwood. All right, I got a lot of prosecutors that don't have any defense attorneys yet, so we're just gonna stand here for a few minutes. I have paid defense attorneys, but Mr. Monterez, I do not have Mr. Shelton yet.
That's okay, Your Honor. I just received a text message from him. He should be logging on in the next minute.
That's fine, thank you. Just in 2 seconds.
Please rise for closed session. See.
Good morning, Mr. Malaro.
Morning, Judge. Is that Tom Moore's ear? Whoa.
It was Tom Moore's ear. Right,
Morning,
Mr.
Mr. Moore.
Monterez, I do have Stephen Shelton. So,
Your Honor, I hate to inconvenience the court, but I'm driving to court. I want to make sure I can give the court my full attention and that I'm safe. Would you mind passing me for just a moment? I'm about 3 minutes away.
no problem. Okay. I got jail, but nobody connected at the jail. Okay. Who do I have in jail room 4?
Zachary
beard.
Rosenberg, Your Honor.
Okay, let me get your file. Mr. Goldstein, okay, this is in the matter of the people of the state of Michigan versus Zachary David Rosenberg. File number 23-21322FC. This is the date and time set for a violation of the probation pretrial hearing. Mr. Rosenberg has retained David Goldstein. Mr. Goldstein, were you able to receive the paperwork on the alleged violation of probation?
No, Your Honor.
Okay, we will get that sent over to you. I believe Ms. Adams can email it because she has it in her system. So the allegations against Mr. Rosenberg are that he violated his terms of probation and they're non-technical. And one, that he assaulted a Kendall Davis. Wait, is this the right one? Yep.
Yep.
That he, Mr. Moore, is that the correct violation of probation?
That's correct.
Okay, that on or about July 14th of 2025, he assaulted Kendall Davis by pushing, elbowing, hitting, and or choking her on or about that date. The second allegation is that he violated criminal law when he took Kendall Davis's phone, allegedly to prevent her from calling the police, and violated a criminal law when they assaulted Kendall Davis on or about that date. So those are the 3 allegations. Mr. Rosenberg is on probation for a delivery manufacturer less than 50 grams, which carries a maximum penalty of up to 20 years in prison. As I said, Mr. Goldstein, we will get that paperwork sent to you. I'm not sure if Mr. Rosenberg has pending charges, but Mr. Goldstein, how would you like to proceed today?
Your Honor, there are pending charges. They are scheduled for tomorrow. My understanding is that at least some of those charges are going to be withdrawn. So I'd like to put this over 1 week so we can see what happens tomorrow.
Okay, so Miss Adams, for next week, are there any days I'm here? I think Thursday, Friday.
Well, we've got arraignments only next Wednesday and then some hearings at 9:30, so I guess we could put this Wednesday.
Next Wednesday at 8 a.m., Mr. Goldstein.
Works for me, Your Honor.
All right, so we will set this over to August 20th at 8 a.m. I'll continue his not guilty plea, and we will see you back via Zoom that day. Thank you, Mr. Rosenberg. Thank you, Mr. Goldstein.
Okay, thank you.
Mr.
Your Honor.
Goldstein, do you need a breakout room or anything?
No, I just want
I
some,
would-
Zach, I've got a Zoom set up for this afternoon.
Okay,
Okay, but I would like to be PR bonded on this. I'm still on a $5,000 bond on something that I've never violated probation before. I've been in here for almost 30 days now. I can't do anything to help myself while I'm sitting here.
Zach, we'll discuss it this afternoon, okay?
Okay.
thank you, Mr. Rosenberg. Thank you, Mr.
Thank you.
Goldstein. Mr. Monterez, just let me know when you are safely pulled over.
I'm ready, Your Honor.
Oh, okay. Mr. Shelton, if you'd like to start your video and audio, please. All right, this is in the matter of the people of the state of Michigan versus Stephen Anthony Shelton, file number 25-22366. I have attorney Nicholas Monterez appearing on behalf of Mr. Shelton. Looks like this is the date and time set for an arraignment, looks like. So, Mr. Monterez, have you received a copy of the felony information prosecutor's request for discovery and witness list?
I have received a copy of the general information, Your Honor. I do not believe that I've yet received a request for discovery nor the witness list from the prosecution at this point.
Okay, so Mr. Sneed is here and he'll make sure if it hasn't been sent, it will be. Do you wish to waive the reading of the felony information?
I do, Your Honor. I wish to waive and stand my client mute after this court to enter a not guilty plea.
All right, and how far out would you like a pretrial?
Your Honor, I would say in the lower court with Mr. McCready, there had been conversation. I'd prefer to not put everything on the record for the purposes of Mr. Shelton's safety, but I will continue those conversations with Mr. Sneed if he'll be taking the case over. I would say I probably need 30 days to get those conversations done and effectuate other conversations that need to take place.
All right, Mr. Sneed is my assigned prosecutor, so it'll probably stay with Mr. McCready, but Mr. Sneed is stuck with me on Wednesday mornings, handling all the arraignments and pretrials. Is that still Mr. McCready's file, Mr. Sneed?
It will be, Your Honor, and our records show that discovery was emailed to counsel back on August 6th, though he hasn't received it. We can resend it.
That'd be great, Mr. Sneed. Thank you.
So I'm going to set this out to September 24 at 8:30 in the morning because it's an arraignment. My staff will prepare the notice of hearing, and we'll see you back on that day, Mr. Shelton, and it would be the same Zoom number, okay? So September 24 at 8:30.
Okay. Thank you, Judge.
Thank you, Mr. Monterey. Hello, so I am ready for Israel Vela,
Mr. Bellman,
Noah Lambley,
Mr. Lambley,
Rodriguez Loftton,
Mr. Loftton,
and Caleb Daniels.
and Mr. Daniels. All right, ma'am, I will get them to you,
All right, thank you.
of course.
Mr. Murphy, I have Aaron Lambus.
Could I
Oh,
speak to
wait.
him in a breakout?
There it
please?
goes. Mr. Lambus, if you'd like to start your audio and your video, please. All right, good morning. This
Morning.
is in the matter of the people of the state of Michigan versus Aaron Wayne Lambus. File number 25-22159FH. I have Matthew Murphy appearing on behalf of Mr. Lambus and Isaac Sneed appearing on behalf of the people. This is a date and time set for pretrial in this matter. Mr. Murphy, how would you like to proceed today?
Your Honor, could I talk to Mr. Lambus in a breakout,
Can't
please?
hear you, Mr. Murphy.
I'm sorry. Can you hear me now?
No, I can hear you, but we can't record you. You're very muted. I swear all the computers are worn out now. We've been having like everybody's computers that works for the county. All of a sudden the mics aren't working. I think they're worn out since we've had them since the pandemic.
Can you hear me now, Your Honor?
A little bit better. It's just very muffled. So you're just be your normal self and speak very loudly.
Your Honor, could I have a breakout session with Mr. Lambus, please?
Yes.
Thank you.
Sorry. I don't know what's going on with all the microphones. All right, Mr. Lambus, I'm going to open up a breakout room for you and Mr. Murphy. Go ahead and join that break. What case are you here on, Ms. Weiss?
Nebs or Eves?
Neves? Okay. I'll just write it down.
Okay, I think Michael's on the other side, I'm not sure.
Michael Dagermar goes in and John Glazier start there.
Okay, I have your dad, thank you.
All right. Mr. Tindle, I just brought you in real quick so that I can add Miss Underwood's initials. She does go to Judge Olsaver's court first. So once she's done there, she will come here and I will call your case, okay?
Yes, ma'am.
All right, I'm gonna pop you back in the waiting room. All right, so I have Miss Betts, Miss Underwood, who else? Mr. Morris, your attorney is. Katie Demott, right? Okay. She is not here yet, but she will be. Anybody else? Oh, what's your, oh, I know. You're Rhonda too, so she's down the hall. She'll come here when she's done. All right. Oh, what's your name?
Paul Johnson.
All right. Who is?
Tamara.
Okay. All right. There, yep, I'm gonna put in person. Okay. All right, Mr. Avila, All right, you are Mr. Malaro. I have Mr. Malaro. Mr. Malaro.
Yes, Judge.
All right, this is, no, wrong one. Let me grab the other file. This is in the matter of the people of the state of Michigan versus Israel Vila Jr., file number 25-22368FH. I have Salvatore Malaro appearing on his behalf, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for an arraignment in this matter. Mr. Malaro, have you received a copy of the felony information witness list and request for discovery?
Judge, I have not. I do have the complaint, but I do not have the information yet. I don't know why.
Oh. Mr. Sneed, do you think you can send that over or verify it was sent over?
I'll send that to Sam right now, Your Honor.
Yeah,
Okay.
Could you email it to me, Mr. Sneed?
I will.
Thanks.
So, Mr. Malaro, do you wish to waive the reading of the felony information?
I would once I receive it, Judge, assuming it's,
Okay.
you know what.
So I'm going to skip
You're
over to
fine.
Mr. Lambus while you're waiting for that.
Thank you.
So, Mr. Murphy, you have had a moment to speak with your client. How do you wish to proceed with Mr. Lambus?
Your Honor, hopefully you can hear me okay. Is this better or do I need to talk louder?
It's better. Yep, it's better.
So with Mr. Lambus, we're going to ask to set trial. Now, I'm also going to ask, there's a motion I had filed to quash the felony information, quash the felony counts. We had placed on the record at the last pretrial that Mr. Baronetto had agreed with me and was going to dismiss those felony counts, and there was no need to proceed with the hearing on the motion. Yet the felony counts remain on there. They haven't been dropped off, and right now Mr. Lambus does not wish to enter a plea of guilty, so we're going to continue the trial. So I would like for a hearing to be scheduled on that motion, so that way if there's any issues, it gets dealt with before we have the jury trial on the case.
Okay.
Your Honor,
So, yes, Mr. Sneed.
Mr. Bayanetto, speaking with him this morning, would like to appear on this case and address the court. If we could pass this, Judge, I did send that information on Mr. Vila over to Mr. Malaro. So I just ask if we could pass this case, and I'll contact Mr. Bayanetto to appear.
Okay. Okay. So now we're going to skip back to Mr. Vila. So, Mr. Malaro, how would you like to proceed on behalf of Mr. Vila?
Judge, now that I have it, I would at this time acknowledge receipt of the information, waive its reading in open court, waive any defects as to time and place or manner of service. We would further acknowledge receipt of the witness list. Mr. Vila will plead not guilty, and Judge, I think he has a court date on September 3rd. We'd ask that this matter be set for further pretrial on that date. I believe
All
we're
right.
probably going to have to order the preliminary exam transcript.
Okay. So, I'll sign that once you present that request. So he's waived the reading of the felony information. I'll enter a plea of not guilty on his behalf, and I will set this for pretrial on September 3rd at 8:30 in the morning. Because it's an arraignment, my staff will prepare the notice of hearing. So we'll see you back on that day, Mr. Vila.
Hey, Mr. Judge Angelo, can I have a breakout with Malaro real quick?
So, Mr. Malaro, do you have time? I know you've got a bunch of cases.
Yeah, I could do it. I got time.
Okay, so I'm gonna open up a breakout room.
Thank you.
And jail Zoom 4. All right, there you go. Join that breakout room.
Thank
All
you,
right,
Judge.
I have Mr. Bayanetto now, Mr. Murphy. So we're back on the record in the matter of the people of the state of Michigan versus Aaron Lambus. So, Mr. Murphy, where'd you go? Oh, there you are. Mr. Murphy, why don't you just do that whole spiel again?
So right now, we're asking to set a jury trial on Mr. Lambus. Again, there's the motion that the defense filed. There was two of them. One was to compel discovery that we Mr. Baronetto provided the discovery, so there's no issue with that continuing. The other motion to quash the felony information, the felony counts, Mr. Baronetto had said he agreed with the argument and that he was going to dismiss the felony counts. Again, there isn't at this point a plea agreement that Mr. Lambert is going to plead to. He wants to continue to trial at this point. So because of such, I was wanting the issue with the remaining counts to be dealt with before the jury trial. And again, I was asking if we could set the jury trial and have a motion hearing set just to make sure, before the trial, just to make sure the issue with the felony counts is dealt with prior to the commencement of the jury trial, because I believe at that point there would be 3 remaining misdemeanor counts.
Mr. Bayanetto, would you like to respond?
Yes, Your Honor. Mr. Murphy's correct. I do agree that the 6 counts of R&O should be dismissed. And when I think we addressed this at the last court date, I had planned on filing the dismissal and was instructed by the court not to. I still have every intention to dismiss those 6 counts. And so I guess we're just looking for some direction on how the court wants us to proceed. I do have the document prepared dismissing just those 6 counts, so we can go forward on 7, 8, and 9.
So my understanding now, because the law changes like on a monthly basis, is if you dismiss all the felonies, it goes back to district court.
And that's fine with me, Your Honor. I can file that today, and if the court
Right,
wants.
if you file the nolle pros through those counts, I'll have it verified with Ms. McGrain, but I think the most recent direction was that if felony counts are dismissed, it goes back to district court.
Okay. I will file that today then, Your Honor.
Then
Right,
I will not
and
ask
send a
for
copy
jury
to Ms.
trial.
McGrain. What, Mr. Murphy?
I was saying that at this point, I will not ask the court to set a jury trial because it will not be in front of this court moving forward.
Yeah, because I'm not gonna set a jury trial now. So, no, all right, so, all right, very good. All right, Mr. Lambus, make sure you keep your address and phone number updated with Mr. Murphy and the court, and Mr. Murphy will make sure you're aware of any dates that are scheduled, okay?
Okay.
All right,
I'm good
thank you,
here.
Mr. Lambus.
Am I good here, Ms. Esla? Am I good?
You're good, Mr. Vila.
Thank you, Mr. Lambus. You have a good day. Okay, I'll talk to you in a couple days.
You two all stop in this week.
All right, sounds good.
All right, clients either stop in all the time or they just dip out and you never see them. All right, so I have Mr. Loftton. Why don't we take Mr. Loftton next? So this is it. Better. Hi, Mr. Loftton, hold on. Mr. Loftton, let me call your case, all right? So we have multiple files on Mr. Loftton. So we have file number 25-22365FH, and that's Mr. Millar, I'm sorry. That is the date and time set for an arraignment. And then we have his other files, which are file number 23-21207FH, 21769FH, which are pre-trials. Wait, no. 23-21207FH is a violation of probation. 24-21769FH is a pre-trial on a new file. 21-20524FH is a violation of probation. So, Mr. Millar, with regard to the arraignment, have you received a copy of the felony information, request for discovery and witness list?
Yes, Judge, we have, and at this point in time, we would acknowledge its receipt in open court, waive any defects as the time and place of service. We would waive its reading. Mr. Loftton will stand mute and ask that the matter be set for a very short pretrial along with his other files.
Okay. All right, so Mr. Loftton has been waiting in the wings for quite a while. So I'm going to set this for September 3rd. at 8:30 in the morning.
I also wanted to
Miss,
know if he could take some time to talk with me.
Mr. Lofton, you're in one of those rooms that has really bad audio. So can
I'm
you
fine.
scoot up?
Yeah. I just want an opportunity to speak with Mr. Imbalaro before I go.
Okay, all right. So hold on a second. So September 3rd at 8:30 in the morning. Miss Adams, I need a bench conference time period before that. Do we have 15 minutes available where I could, who's the assigned prosecutor on this?
So Judge, the problem is there's two different prosecutors. They're trying to corral them both and
Who
get
are
it worked
they?
out. Mr. Sneed and Mr. Bayonetto. So yeah, if we could do a quick bench conference, I'm sure we can get this worked out.
So Miss Adams, I'm gonna set this for a pre-trial on September 3rd at 8:30 in the morning. But I would like a bench conference date before that with Mr. Sneed, Mr. Bayonetto, and Mr. Malaro. And I don't know if you have something available. It'd be like 15 minutes, anytime, any day.
You've got an all-day trial on August 26th if you want to do a 1:30.
Okay, so August 26th at 1:30, are you guys, Mr. Sneed and Mr. Malaro, are you available for 15 minutes?
Looks like I'm available, Judge. Let me check my calendar. They won't let me have a vacation anymore, so I'm kind of
You've used up all your time.
trapped working. Yeah, I'm good on the 26th.
Yes, sir.
Okay, so I'll see you in person for that bench conference on August 26th at 1:30. And then pre-trial on September 3rd at 8:30 in the morning. Mr. Malaro, there's only one file set for pre-trial, so I'll have my staff put off the notices for all of them. So, because we do them for VOPs and we do them for arraignments, so.
And
All right,
Your
Mr.
Honor,
Loftton.
Yes. I'm correct?
Hold
If we
on,
get this,
one person at a time, and Becky's more important than you, Sam. Miss Adams?
that's for sure.
I was just going to ask, do you want Mr. Lofton in person as well for that bench conference?
Not for the bench conference.
Okay.
Unless, Mr. Malaro, do you want him here?
I want Mr. Lofton. That's a correct statement, Judge. So, yes.
Okay, so we'll have Mr. Loftton brought over in person too.
But Your Honor, am I correct that if we get this resolved before that date, we can bring it before the courts?
Absolutely.
All right. Thank you.
All right, Mr. Malaro, I know you got a heavy caseload this morning. Do you have time to talk to Mr. Loftton?
I will always have time for Mr. Lofton, Judge.
All right, so Mr. Lofton, I'm gonna pop you in a breakout room with Mr. Malaro. Go ahead and join it. When you're done, you're done. All right?
Thank you, Judge.
Okay, so. Underwood. Mr. Murphy, I have Mr. Daniels. So I'm gonna grab his file. This is in the matter of the people of the state of Michigan versus Caleb Daniels. We have file number 24-22081 FH. We have 25-22256 FH. So we are set for jury trial on August 27 at 10:30 a.m. This is the date and time for the last pre-trial in this matter. So, Mr. Murphy, how would you like to proceed today?
Your Honor, at this time, we wish to continue with the jury trial. I think I'm probably going to ask to schedule a Cobb's conference before then, just to make sure we touch base one last time about trying to get a plea worked out and some sentence. Your Honor is full aware that we've had quite a bit of effort in regards to Mr. Daniels, but that's where we're at right now. I believe also there is a contempt of court on 24-22081 that Mr. Daniels wanted to plead guilty to today to clear that up before we proceed any further with the cases.
Which file?
I thought it was 24-22081 for maybe failure to appear.
Yeah, there's a contempt and a VOB.
Was the contempt on the 2522256?
No, there's a contempt on the 8-1. I just gotta go back, figure that out. It's back quite a way. All right, yep, we have a failure to appear for pretrial on 24-22081 FH. He wants to plead to it.
Yes, Your Honor. He's gonna ask to plead guilty to it and be given credit for time served.
All right, what's his bond on the underlying file?
We're gonna ask the court to clarify that as well, I guess, moving forward. There's a 5,000 cash surety bond, I think, on his 2-5 file. I'm not sure what the bond is on the 2-4 file.
Miss Adams, are you able to tell me what the bond is on file number 24-22081 FH? Not necessarily the contempt of court. I'm looking at a premium. Sometimes I don't get file. Work. On condition, he's got a PR. So Mr. Malaro, or Mr. Let me see. So there was a PR bond granted back on November 12 of 24. I think October 30th. And bond continued, released to Dawn Farms. And let's see, exam held, defendant bound over. He did not complete Dawn Farms, correct?
Yes, I did.
I think he did, Your Honor.
So on the underlying file, 2201.
I do see.
I don't have time to address bond today, Mr. Murphy, and I'm not going to release them. So if you think that, please, I usually dismiss contempt of courts, either upon conviction or pleaded guilty, but Mr. Daniels has an extremely long history of addiction issues that has caused him to fail to appear for court, violate bond conditions, violate his bond conditions, violate probation. So I am going to set his bond at 25,000 cash on this file, and you can schedule a bond hearing if you'd like, Mr. Murphy. But he is a flight risk. He fails to show up all the time. He's a great guy. He's a good person, but
I understand, Your Honor. I was just going to ask if could we set the Cobb's conference now, or do you want me to contact the court later about that?
you have to contact Miss Adams. So I'm going to change his bond to 25,000 cash on that file. And then you can schedule a bond hearing, or we can address it at a COPS conference. You guys send an email to Miss Adams.
May I address the court, Your Honor?
Yes.
I'd just like to advise the parties that the plea offer that I had sent on July 31st expires today. So, if we'd like to schedule a plea hearing later this afternoon, if the court's available, that's fine. But
what is the plea offer that was offered on July 31st?
give me 1 second, Your Honor. I can bring that up. Your Honor, the plea offer is in file 2422081. The defendant would plead to count 2, a larceny in a building, which is a 1-year. In file 2522256, he'd be pleading to count 1 with a habitual 4th. There would be a sentence recommendation of 36 months MDOC, boot camp eligibility after 18 months, Any sentence in the other file would run concurrently. We would, in file 22081, dismiss the felony count 1 and the habitual 4th supplement as well.
So there's a misdemeanor in file number 24-22081FH.
We have some additional terms, Your Honor. The parties acknowledge there was a Cobb's evaluation held on May 29th, 2025, where the court had committed to that sentence previously stated, and that this agreement would expire on or before August 13th.
And then the plea offer on 25-22256FH is plead to the police officer fleeing 3rd degree. He has multiple prior felonies, so it would be with 4th offense notice. And then the Cobb's would be to 36 months MDOC with an agreement that he could be released to boot camp. And then if Mr. Daniels is convicted, he's looking at life in prison on that file.
Yeah, I think actually we did have some email communication, and I think we were willing to lower that to 34 months just to jive with the guideline, I believe.
All right, so Mr. Murphy and Mr. Sneed, you know, if you want to meet with me today, I have a full docket. I can probably fit you in. But, you know, you guys to schedule that with Miss Adams.
Mr. Daniels, you want to talk in a breakout?
Yes, I would. Yes, I would. Thank you.
Yana, can we please talk in a breakout real quick? I'm sorry.
Yeah. Mr. Daniels in jail cell 5. In the breakout room.
Your
All
Honor,
right.
also, Mr. Malaro.
Mr. Loftton. You know how I call you Mr. Loftton?
Yeah, no, I was just trying to say that.
So I really like formalities. So it's Mr. Malaro. So Mr. Loftton, if you had a chance to talk to your attorney.
Yes, yes, ma'am.
Mr. Malaro, are we all set?
Yeah, I'm good, Judge.
So what else do you need, Mr. Loftton?
Nothing. He just told me to come back into court.
Okay. All right, Mr. Loftton, we'll be back around with you. We got a couple meetings set up for your case, so we'll see you back, all right?
Okay, thank you.
Thank you. All right, who do I have in jail Zoom 6?
Noah Lambley.
Say it again.
Noah Lambley, ma'am.
That room just doesn't have good audio for some reason. Some of them do, some don't. All right, you are Matt Murphy. He's in with a client. Anybody else have Sam Millar? Matt Murphy, no. Michael Dagger Margosian, you have one case. Let me find you. You have Timothy Neves, correct?
Correct. Sir.
Mr. Neves, you want to?
Yeah, he's in jail.
This is Judge Anslone. I am ready for Timothy Neves.
Neve?
Neve, N-E-V-E-S.
E-N.
N-E-V as in Victor, E-S.
Okay, you need to pay now?
I'm sorry, I'm ready for him now, yep.
Okay.
Thank you. All right, Mr. Murphy, we are back with Mr. Daniels. Are we all set?
Yes, we're ready to, he doesn't want to accept the plea at this time, Your Honor. We're ready to continue to the trial, and I'll try to schedule a Cobb's when I get a chance to.
I can't hear you.
Yes, we're ready to continue the trial, Your Honor. He does not want to enter a plea at this time.
Okay. All right, so the plea offer is good till today at 4:30, you said, Mr. Sneed.
Correct.
Okay,
Thank you.
so, okay, all right. Thank you, Mr. Daniels, you're all set.
Thank you.
Thank you, Your Honor.
Anybody else? Anybody in here have Matt Murphy? No. So Mr. Murphy yep, you do. I'm sorry. I forgot about you, Mr. Lambley. Let me grab your file. All right, this is in the matter of Noah Lambley, files number 24-22063 FH, 25-22205 FH. This is the date and time set for a pretrial conference. I have Isaac Sneed appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Lambley. So, Mr. Murphy, how would you like to proceed today?
Your Honor, there's a plea offer that would involve Mr. Lambley pleading to the malicious destruction of property in file 2422063, a no contest to that. As charged to the felony with no habituals. I don't believe he has habitual offender status. And then file 25-22205 will be dismissed. Any restitution to be had on that, he would agree to pay if there's any restitution to be had on that file. I haven't had a chance to talk to my client about this. Could I have a breakout, please, and discuss the matter with him before we proceed?
So, and like I said, your microphone, you're kind of fading off at the end. So on 24-22063, the plea would be to plead to count 1.
Yes, Your Honor.
Oh, much better. And then 25-22205 would be dismissed, but he'd be responsible for any restitution.
Yes, Your Honor.
Okay, so I'm going to open up a breakout room.
Thank you.
Yeah. And all right, Mr. Lambley, go ahead and join that breakout room.
Thank you, ma'am.
Waiting for the jail. Mr. Morse, you want to come up to the podium? Because you have Katie DeMont, correct? Yeah. All right, so this is in the matter of the people of the state of Michigan versus Katerina DeMont versus Harold Joseph Morse. I have Katerina DeMont appearing on behalf of Mr. Morse, and I don't have, this is a Bob, so I don't have a prosecutor. So let me see here. Okay, so there was a failure to appear. I quashed the bench warrant. Mr. Morris was in contact with his attorney. So, Ms. DeMont, how would you like to proceed today on behalf of Mr. Morris?
Your Honor, we adjourned this at the last hearing, so Mr. Morse could obtain a loan to pay this restitution. It's my understanding that that loan still has not been obtained and the restitution has not been paid. So I think he's still working on it. I just don't necessarily know what the court wants to do at this point, if we want to set for a full hearing or.
All right, who's your PO? Joanne Holly.
Yeah, I have documents.
Oh, yeah. Oh, so Mr. Morris, stand at the microphone and speak up loud for me.
We have documents showing that the loan and then when it's gonna come through, so.
Okay, I'll adjourn this out a couple more weeks. All right, Mr. Morris. So, Ms. Dumont, I'm gonna set this out to September 3rd to see what happens. So, Ms. Adams, you're what?
I'm out the first week of September. I'm sorry.
It says on the thing, it says September 17th.
Says, funding date is, September 17th.
The funding date says September 17th.
All right, I'm gonna set it out to September 24. Ms. Adams, at 8:30 in the morning, could I get a notice of hearing from Mr. Morris? All right, so Mr. Morris, just sit down right behind you and we'll get you a notice of hearing, all right?
Mr. Morris,
Yes,
I need Morse to know that next week is report day, but he has to report in the morning because the building's closed in the afternoon.
Okay, 8 o'clock.
8 o'clock, Miss Holly?
Yes.
Okay,
Thank you.
thank you. Let me close that breakout room. Noelle Johnson is present, so I'm gonna take her next, Mr. Mont. I'm gonna skip back to Mr. Dagger Margosian. So, Mr. Dagger Margosian, with regard to Mr. Lambley.
Needs, Your Honor.
Your Honor, that's my case.
Mr. Murphy, with regard to Mr. Lambley.
Your Honor, Mr. Lambley wants to accept the offer. He wants to plead no contest to the destruction of property and agree to pay restitution in both files over a period of however long it takes him to pay it.
Okay, Mr. Dagger Margosian, are you taking a plea on your client today as well, or setting a date?
We will be asking for an adjournment because we don't have the preliminary exam transcript. But it
So
will be.
in the matter of your Mr. Timothy Neves.
Yeah.
Yep, and Mr. Morse was given a notice of hearing. Thank you, Ms. Adams. So in the matter of the people of the state of Michigan versus Timothy Neves, file number 25-22222 FC. I have Michael Dagger oh, wait, Ms. Weiss. Can you go see if Ms. Weiss is next door? Yes. Hold on, we need Ms. Weiss on that, all right? So I'm going to, hold on, skip around one more time. Mr. Mond, are you setting a date on,
Noel, John,
are you setting a date or a plea?
we would ask for one more pretrial on her.
All right, so Miss Johnson, come on up. So in the matter of the people of the state of Michigan versus Noelle Marie Johnson, file number 25-22254FH. I have Matthew Murphy appearing on behalf of the people and Katerina Dumont appearing on behalf of Miss Johnson, who's.
You said Matthew Murphy on the people.
Oh, Katerina Dumont.
Okay.
We're on Noelle Johnson.
Yes.
She's not.
She's not next door. Okay, Becky, could you call Jackie Weiss?
I can cover that, Judge, for Ms. Wise.
Okay, so I have Katerina Dumont appearing on behalf of Noelle Johnson. So Miss Dumont, how far out would you like the pretrial?
Your Honor, whatever works with the court. She has been complying on bond. She's been twice weekly testing. We would ask if she could be reduced to once a week. We have an offer that contains 7411 if she's eligible, but I need to do some digging on my end to make sure she is eligible for that before we go forward.
Okay, are you testing with Darren Coast?
Yes, I am. I test, my color's green. I test twice a week.
Okay.
You have this? You? Like right now, yeah. Yep.
Okay, I'm not gonna reduce.
Yes, I'm 26.
You know, I hate that when people ask that and they're like, no, why do you ask? But
6 weeks.
so I am not going to reduce our testing, Mr. Mont, right now. This is, you know, a very critical time for both her recovery and everything else. And so I'm not going to reduce testing. I will set another pretrial for September 17 at 8:30 in the morning. Could I get a notice of hearing, Miss Adams, for Miss Johnson? So September 17, I'm sorry, at 8:30 in the morning. And we will give you a notice of hearing today, okay? So have a seat behind you and we'll get you a notice of hearing.
Thank you.
All right, so I am, Mr. Sneed, you said you'd cover for Neves?
Yes, Judge.
All right, so Mr. Dagger Margosian, we're back on the record in the matter of the people of the state of Michigan versus Timothy Neves. This is date and time set for pretrial. I do see the people filed a notice of intent to use other acts evidence. And so how far out do you want a pretrial, Mr. Dagger Margosian?
Well, Your Honor, there was a preliminary exam held in district court, and we don't have that transcript. If the request hasn't been entered, I guess we would have to ask for maybe an adjournment of 60 to 90 days to get that exam transcript.
Did you put the request in?
If it hasn't been done, we would put it in today and the timeline would start running from today.
All right, and I will sign that today, so. Let's go to November 5 at 8:30 in the morning. You can do the step in order to adjourn. So, Mr. Neves, if there's a resolution on this case, Mr. Dagger Margosian most certainly will get you in right away, because I do accommodate people right away. So one way or the other, if you need to move that up, Mr. Dagger Margosian, I will accommodate that, all right?
Thank you, Honor.
All right, thank you, Mr. Neves, your bond's continued.
Thank you.
Okay, now we are done with Mr. Dagger Margosian and we are back to Mr. Lambley. So, Mr. Lambley, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name for the record?
Noah Lambley.
All right, so Mr. Lambley, you have heard the statement of, well, Mr. Sneed, was that a correct recitation of the plea offer?
Yes.
All right, so Mr. Lambley, go ahead,
I'm
Mr.
sorry, I just
Murphy.
wanted to clarify, it was going to be a no contest plea, from my understanding. Is that okay, correct, Mr. Sneed?
No objection.
All right, Mr. Murphy, are you prepared to put the factual basis on the record then?
I can if there's no objection by Mr. Sneed.
No.
Okay, so Mr. Lambley, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead no contest on file number 24-22063FH to count 1, malicious destruction of personal property, 1,000 or more, but less than 20,000, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine, or 3 times the amount of destruction or injury, whichever is greater. So is it your intention to plead no contest to that count today?
Yes, ma'am.
Now, Mr. Lambley, do you understand? Say it again.
We're not picking them up very
So,
well.
Mr. Lambley, if you can scoot forward a little bit and just speak a little bit louder for us. Thank you. So do you understand, is it your intention to plead no contest to that?
Yes, ma'am.
All right, good. And you understand that any restitution there may be on file number 25-22205FH, you would also be responsible for that as well. Do you understand that?
Yes, ma'am.
Are you satisfied with your attorney and the advice that he has given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is.
Mr. Murphy?
That's correct, Your Honor.
Was there any sentencing agreement? I can't remember.
There was no sentencing agreement, Your Honor.
Okay, okay. Is that correct as far as you're aware, Mr. Lambley?
Yes, ma'am.
Right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Lambley?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms and conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Sir, do you have any questions about the rights that I've given to you?
No, ma'am.
So your attorney has advised you're going to be entering a no contest plea. So your response to my next question would be either no contest or not guilty. Do you understand that?
Yes, ma'am.
How do you plead to the charge that on or about June 25 of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense listed under count 1, malicious destruction of personal property, 1,000 or more, but less than 20,000?
No contest, ma'am.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand or plead no contest to this charge? Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Sneed?
No, Your Honor.
Mr. Murphy?
No, Your Honor.
All right, Mr. Lambley, say that again a little bit louder, Mr. Murphy.
No, Your Honor.
Okay, thank you. Has your attorney promised you, Mr. Lambley, any particular sentence or estimate of what your sentence will be?
No, ma'am.
All right, is it your own choice to plead no contest?
Yes, ma'am.
All right, so Mr. Murphy, could you please place the factual basis on the record?
Yes, Your Honor. We would agree and stipulate, based upon the police report in this matter and the probable cause affidavit, that on June 25th of 2024, Mr. Noah Lambley was in the city of Adrian, the county of Lenawee, the state of Michigan, by virtue of him being inside the Adrian District Library. And that while he was in the Adrian District Library, he suffered a mental health breakdown, was causing a scene. During that incident, he destroyed maliciously and with intent some charging stations, cell phone charging stations. We would agree that the value of those charging stations was $1,370.59. I believe we've satisfied the factual basis, Your Honor.
Mr. Sneed?
If I could just have a moment to double check that amount. Yeah, that's accurate, Judge. I have no objection.
All right, so based on the facts placed on the record and from the information contained in the police report as recited by Mr. Murphy, the court finds beyond a reasonable doubt that on or about June 25 of 2024 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense of malicious destruction of property, 1,000 or more, but less than $20,000 by damaging cell phone charging centers at the Adrian District Library, and that the amount of the destruction was $1,300 and what, Mr. Murphy?
$70 and 59
$1,370.
cents.
$1,370.59. And then there was a shipping and handling fee of $95.62 added to the invoice. This is on page 6 of the police report, Matt.
Yeah, I mean, we would have no objection to whatever the restitution would be determined at the sentencing. So,
Okay, Mr. Sneed, is there a known restitution amount on file number 25-22205FH? Not yet.
Oh, sorry, I was muted. If I could have a moment here, I'll look at that.
Sure. right, so I, accept the no contest plea. Has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, thank you.
Mr. Murphy?
Yes, Your Honor.
The plea was given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. And I am going to set sentencing. Are you available October 3rd, Mr. Murphy?
Yes, Your Honor.
For October 3rd at 8:15 in the morning. Mr. Lambley, you pled no contest, and that was for lack of memory, Mr. Murphy?
Yes, Your Honor, due to the incident involving his mental health episode.
Okay. So when you meet with the probation department, obviously you don't have to speak about the incident itself, but be truthful with them about your background. They'll prepare a pre-sentence report. Mr. Murphy will get a copy of that and discuss it with you, and we'll see you back on October 3rd at 8:15 in the morning. Mr. Sneed, were you able to find restitution? I mean, we can get it for sentencing. But...
Well, I see that the ankle monitor was removed. I just don't know if it was damaged or not. So maybe during the PSI phase that could be determined, included in the conviction file.
All right, so we're all set, Mr. Lambley. Thank you.
Your Honor, could we possibly address
Mr.
bond?
Lambley, do you want to be present in person or via Zoom?
Person.
Okay, I'll make
Your Honor,
that in
could we
person.
possibly address bond? I'm sorry.
Yes.
Mr. Lambley has been in custody now since, well, for 5 months, I believe, since March, if I'm not mistaken. We do understand the nature of that was because he was taken into custody, and obviously there was the cutting of the tether off. But Mr. Lambley, again, he took responsibility for the incident at the house at the library. He was reviewed for his mental health, for a competency review. He is doing much better now in regards to that than he was before. I do understand that he doesn't have a home. He would be at a homeless shelter.
I have a place. I have a resident.
Oh, I'm sorry, Your Honor. I was wrong about that. But Mr. Lambley is not a flight risk, I don't believe. And in regards to threat to society, I believe the issue is being dealt with, and that he's not a pending threat to society. So I'd ask the court to consider a PR bond.
Mr. Lambley, I have you listed as homeless. So where?
Its address is 404 Moser Avenue. It's my cousin Dean, and I can stay there until the remainder of the court issues, or until I get the bills paid off. He said until I'm out of trouble, basically.
Can anybody verify that, Mr. Murphy, that he has a place to go to? Because we also have a contempt of court for, let me find the contempt of court.
Apply for cutting off the tether, not appearing.
I can't hear you, Mr. Murphy.
Is the allegation on the contempt for the new charge the removal of the tether and not appearing?
Yeah. Oh, probably for removing his tether and not appearing. That sounds like a valid reason to have a contempt of court. I thought it was just going to be for something simple, but that's not something simple.
Well, that's what the new charge was for, Your Honor. That's why I was just assuming that was
So
what.
while he was on tether and bond, he damaged his tether and absconded?
Yeah, that's
So
the
I'm gonna deny
allegation
your
of the new charge
request
that he
for
moved his
bond.
tether.
You can remotion it. I'll deny your request for bond and you can remotion it. Thank you.
Thank you, Your Honor.
All right, thank you. All right, you're all set, Mr. Lambley.
Thank you, Mr. Lambley. I'll talk to you soon.
Okay.
Okay, so everybody in here has Rhonda Underwood, right? And I don't have Rhonda yet. She's next door. We might take a recess and have my bailiff Glariter. So I'm gonna step off the bench and
Your Honor, did we call Darius Collins? He was 8 a.m.
no, he didn't appear. So in the matter of the people of the state of Michigan versus Darius Collins, we have 3 files. 24-21767 FH, 24-21798 FH, 24-22082 FH. I think John Glazier zoomed from home today. Maybe he can go next door and see if Mr. Collins is home. But he failed to appear, so I'm going to issue a bench warrant and set bond at $25,000 cash on each count. In the matter of the people of the state of Michigan versus Amir Keyshawn Norman, file number 24-21913 FH. He has failed to appear. I'm going to issue a bench warrant for his arrest, set bond in the amount of $25,000 cash. In the Mr. Tindle, oh, I got Brian 5. Never mind, I'm not getting off the bench. Let's see. Mr. Tindle's here. Get the jail. Mr. Fry, I'm gonna get Mr. Adams from the jail.
Thank you.
Hi, so I have one last person and it's Mr. Adams.
Mr. Adams?
Louis Alfred Adams.
All right, I had Hayward on my sheet as well.
No, I saw him yesterday. He's supposed to see district court today.
Perfect, thank you, ma'am.
All right, thank you.
Yeah, bye-bye.
Bye-bye.
Judge, I think Skyshon Tindle, this is his first show cause. I don't know that he has Miss Underwood yet.
He's in my waiting room. Oh, he doesn't have an attorney yet?
I don't think so. This is his first show cause on this one.
Let me see.
That's correct, Judge.
I know Becky told me a few of them. So. Dismissed. Mr. Tindall, good morning. How are you?
I'm good. How you doing?
I'm good. So this is in the matter of the people of the state of Michigan versus Skyshon Tindall. We have 2 files, 20-20027 FH and 22-20717 FC. Mr. Tindall, we are here today on a request and summons for probation violation. The allegations against you are that you committed the following technical probation violations. One is that you failed to report as instructed on June 10 or June 17 of 2025. The next one is that you failed to notify the probation agent of your current residence. Failed to maintain employment. I guess you might have lost a job back on July 4.
I had broke my
Hold
hand.
on, don't say anything yet, Mr. Tindall. Hold on, let me go through this. Let me offer you an attorney and then we'll go from there. And that on July 2nd of 25, Adrian police officers asked you to submit to a PBT and you refused, went inside and said something along his PO on shit, I don't know. And then the other allegations, you behaved in an assaultive, intimidating manner by not complying with police commands on July 2nd, when instructed to go inside the apartment where they were responding to a report of several individuals fighting. You were being allegedly loud and you were told several times to go inside, but would not. And then, I think that's it. So those are the allegations on both files. So on file number 20-20027 FH, if you plead guilty or found guilty, the maximum penalty could be up to 20 years in prison. And on 22-2071 FC, you're on probation for a felonious assault. So the maximum penalty could be up to 4 years in prison. So, Mr. Tindall, those are the allegations against you. You do have a right to hire an attorney. If you can't afford to hire an attorney, we will appoint you an attorney. So, are you going to hire an attorney or you want us to appoint you an attorney?
I'll take a court appointment.
Okay, so I'm gonna enter a plea of not guilty. I'm gonna pop you back in the waiting room. And then, Mr. Tindle, it's kind of a busy morning, you know, Wednesday, so you might be in there for a minute. So, we'll bring you back in when we get your attorney, okay?
All right, thank you.
Thank you.
Thank you, Judge.
Thank you. Okay. Take some put it back in. I'll be right back. Stretch your legs.
Where you go? Where you go? Oh, yeah. And then another guy stole like 1.7 million from the deed. He got 1 year prison. Wow, that's crazy. He was under the influence and didn't want to. How many times have you gone with influence? Right. I'm sorry, but I don't have it. Yeah. When you're on your own property. Time was waiting like this. Oh, he's in the room, yeah. What, yeah. Yep. That's where he needs to be. You ready for school? Yeah, because of this.
Yeah. Cross.
Oh my gosh, are you running in this weather? Oh my gosh. You gotta stay hydrated, right? He was doing great. Yeah. Oh my gosh. So what's the longest you run? Okay, well, the sweat, when he got out, it was summer practice. He was doing good. People places to stay, and that's. Yeah, that's good. Well, just be careful, stay safe. I was 17 months and I fucked it up. Yeah. I was wondering about. I got it. I went on a run for about 2 months. Yeah. Exactly, that's why I'm going out. Exactly. But at least you went a long way. Yeah. It's a hard. But I have to do it right now. I have to do my. Yeah. That's all. Hopefully it's conflict. You know how many times I got to watch you. It's something like 99. I can't believe. Yeah, I've never had a tether or nothing, so that, yeah, it makes me feel. When you. Didn't know how to do it, so yeah. Sure, I got up, started bawling this morning. I'm like, oh my God. I woke up at fucking 8:09 and my alarm went off at 7. And then I usually just like swipe it and it turns it off. Yeah. Well, I fell back to sleep because I'm on traffic on therapy. Yeah. And I was like, just.
Well, can you hear me?
There ain't nobody in the courtroom. And then I called. I'm getting late. I'm like, I just woke up. Yeah. And like, and I was like, cause I look at Doc every day. I check my Doc to make sure that if you guys, everybody has court, I want to make sure you guys know that. Here's just like, hey, right. You should say
And so when I was going to the doctor. Okay, I was like, oh my.
And I was freaking out.
And I'm like,
you're supposed to be here at 8.
And I'm like, you're not being personal. Nope. I was last. Right?
Can you see me?
Yeah. Who's that? Oh, is it? Yeah. Hey, here she is. Now Judge ain't here.
Judge will be right with you in just a minute.
I know. Like back in the day when I was with my baby daddy, I literally got charged for forcing me out of buildings because I was in the vehicle in a different parking lot, sleeping. And I didn't know what they were doing. Yep, I literally got charged for forcing me out of building and I wasn't even there.
Oh, didn't it? Aquarium,
Yep.
place still.
Yep. And baby daddy's friend stole a safe and yeah. Luckily I only got this thing. Really. Right.
How are you? Good, it's good to see you. Thank you.
Yes. Oh, I thought, no, 10 days, that's what 10. I thought. Oh, that's right, Rachel sent out a text. Okay. Oh, good.
Please rise for correspondence session.
Next week.
You may be seated.
All right, Mr. Adams, can you hear me?
Yes, ma'am.
All right, Miss Underwood, I've appointed you to represent Skyshun Tindle. Did you receive his paperwork?
Yes, I did, Your Honor.
So I'm gonna bring him in and put you guys in a breakout room while I take care of Mr. Fry and Mr. Adams, okay?
Okay.
And that way I have some, and then I have a few people in the courtroom for you as well.
Receive his paperwork?
All right, Mr. Tindle.
We're getting an echo.
I know we are, so
Okay.
give me a minute.
Thank you, Judge.
Mr. Tindle, I'm going to put you and Miss Underwood into a breakout room.
Okay.
So there you go. All right, so Mr. Fry, we have Mr. Adams. So this is in the matter of the people of the state of Michigan versus Louis Alfred Adams Jr. We have file number 24-21947FH, 24-21948FH, 24-21949FH, 24-22011FH, 24-22012FH, and 25-22337FH. I have Isaac Sneed appearing on behalf of the people and Brian Fry appearing on behalf of Mr. Adams. This is the date and time set for multiple things. One is a pretrial conference, obviously, but I have received his criminal responsibility as well. So, Mr. Fry, did you receive that?
I did, Your Honor.
Mr. Sneed, did you receive that?
Yes, Your Honor.
Okay, excellent. I know it's not a competency order. So we don't need to place that on the record. But so Mr. Fry and Mr. Sneed, how do you wish to proceed today?
So, Your Honor, we have been waiting for that report. We did finally get that. Miss Arnold did make a plea offer yesterday afternoon, but I was in court, so I haven't had a chance to run guidelines or to discuss it with my client. So we'd be requesting an adjournment of, at least a couple weeks or whenever the court is next available after that, so I can run some guidelines and discuss that with my client.
So, Mr. Fry, what I'm gonna do is I'm gonna set it for September 17th at 8:30 in the morning. But if you run the guidelines and you have a discussion with your client and he wishes to avail himself of the plea bargain, I'll bring you in on any other day than a Wednesday. So I'll get you in right away, but September 17th is my next available. But like I said, Mr. Adams, if your attorney presents you with a plea that you wish to avail yourself of, I'll get you in as soon as possible, all right?
Okay.
So I'm gonna set September 17th at 8:30 in the morning, and Mr. Fry, you can prepare the stip in order to adjourn. Mr. Sneed, can you sign your name with permission?
Yes, thank you.
All right, anything else we need to address on the record, Mr. Fry or Mr. Sneed?
No, thanks.
No, Your Honor, thank you.
All right, thank you, you're all set, Mr. Adams. Mr. Glazier, just for an FYI, Mr. Collins would show cause to appear for court today, and he failed to do so. So a bench warrant was issued for his arrest and bond set at $25,000 on each file. I know you're not appointed to represent him. You're also muted, but I didn't know if you wanted to go knock on his door or whatever. And you're muted. You're still muted. Can't hear you. Still muted.
His mother came over and talked to me a couple days ago, so I don't know what's going on. I'll let her know though.
Okay. All right. So we are back with Miss Underwood. Okay. Mr. Tindle. Okay. So Miss Underwood, you have had a chance to speak with Mr. Tindle.
Yes, Your Honor. Thank you.
All right. And how would you like to proceed today on behalf of Mr. Tindle?
We would ask the court to enter a not guilty plea on Mr. Tindle's behalf and schedule this for a pretrial in maybe 2 weeks, Your Honor.
I don't think I can. I can do September 17th.
Thank you.
At 8:30 in the morning, and we'll mail out the notice because it's about. All right.
Thank you.
Right, Mr. Tindall, you're required to continue to report to the probation department and comply with your probation terms. Does he report next week, Ms. Holly?
Yeah. Don't forget in the morning because remember the afternoon is closed. The building's closed.
Yes, ma'am.
So you got to in the morning next Tuesday, Mr. Tindall. All right.
Yes, ma'am.
Thank you, Judge.
All right. Thank you. All right, Miss Underwood. So I have Julia Betts. Miss Betts, you want to come up to the podium? So in the matter of the people of the state of Michigan versus Julia Betts, we have file number 23-21519FH, 23-21264FH, and 22-21100FH. We're gonna move that microphone for you. So I have Rhonda Underwood appearing on behalf of Miss Betts. So Miss Underwood, how do you want to proceed today?
One moment, Your Honor. We would ask for a brief adjournment in this matter, Your Honor. I believe we have some issues we have to talk about. So I would ask for a brief adjournment in this matter.
All right, I'm going to set this out, and Ms. Adams, I'll need a notice of hearing for September 17 at 8:30 in the morning. You know you can zoom in, right?
Thank you.
All right, Miss Underwood, she doesn't want to adjourn it. Do you want a breakout room with her?
Sure.
I talked to Tom.
Okay.
I talked to Tom already.
Can I be part of that, Your Honor?
The breakout room, yes. Ms. Betts, my bailiff's gonna take you out in the hallway. He's gonna connect you to that Zoom device. And then I'm gonna put you in a breakout room with Tom Moore and Rhonda Underwood. Mr. Glazier, in the matter of the people of the state of Michigan versus Tomas Angel Avila, file number 25-22279FH. I have John Glazier appearing on behalf of Mr. Avila, and I have Isaac Sneed appearing on behalf of the people. Says the date and time set for arraignment in this matter. Mr. Glazier, I do not have Mr. Avila. Is he in your office?
He's right
Look,
here.
he's in your office. Hi. So, all right, hold on. Let me open up this breakout room. So, Mr. Moore, Ms. Underwood, and Ms. Betts. All right, I'm gonna send you a request. Join the breakout room. So join that breakout room. So, Mr. Glazier, you have Mr. Avila present with you. So, Mr. Glazier, this is the date and time set for pretrial. I do have an amended information, which is added see account 2, attempted carrying concealed weapon, which carries, well, I think that's wrong, because carrying concealed weapon carries a 5-year penalty, and the attempted carrying concealed weapon says it also carries a 5-year penalty.
No, I think it'd be 2.5, or I believe.
So Mr. Sneed will need that amended information amended.
Thanks, Judge. We'll get that fixed.
Okay, so that would be a 2.5-year felony. Mr. Glazier, how would you like to proceed with Mr. Avila?
Your Honor, he's going to plead guilty to count 2 with the understanding count 1 will be dismissed at the time of sentence, that there's he would get a delayed sentence and no immediate jail as a part of that plea.
Yep, that's what I have in my notes. That is correct recitation of the plea. Mr. Sneed.
Yes.
All right, so I'm going to be, so Mr. Glazier, not that I don't like you, but I don't need to see you. I need to see your client. So can you shift the laptop to him? And I need to make sure the microphone's picking up. So Mr. Avila, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so I'm going to need you to speak louder. That was fine, but going forward, just speak kind of loud, okay?
Yes, ma'am.
All right, can you state your full name for the record?
Thomas Angel Avila.
Thank you. So, Mr. Avila, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead under a delayed sentence to count 2, attempted carrying a concealed weapon, which carries a maximum penalty of up to 2.5 years in prison and a $2,500 fine, along with mandatory forfeiture of the weapon or device? So is it your intention to plead guilty to that?
Yes, ma'am.
Okay, do you understand that sentencing will be delayed for 1 year? Ms. Adams, I'm gonna need Mr. Coast. So you will be on bond probation with our trial or our pretrial services coordinator, and there would be an agreement to no upfront jail, but at the end of that year, the charge would be dismissed, Mr. Sneed?
Yes, Your Honor.
Okay, so do you understand all of that, Mr. Avila?
Yes, ma'am.
All right, are you satisfied with Mr. Glazier as your attorney and the advice that he has given you?
Yes, I am.
Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Glazier?
That's correct, Your Honor.
Mr. Sneed?
Yes, Your Honor.
Is that correct as far as you are aware, Mr. Avila?
Yes, ma'am.
So, Mr. Avila, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have a right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. Let me let Mr. Costin. Good Good morning, Mr. Coast. I am here on Tomas Avila, and he's going to be pleading under a delayed. So he'll be supervised by you for 11 months, okay?
Very good.
All right, thank you. So, Mr. Avila, you have a right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Avila?
Yes, ma'am.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So, Mr. Avila, do you have any questions about the rights that I've given to you?
No, no, ma'am.
All right. How do you wish to plead to the charge that on or about January 18 of 2025, and I don't have a venue. I have Lenawee County and Lenawee County. Mr. Sneed, do we know where this occurred?
Yes, could I just have 1 second, Judge?
Yep.
Yeah, they gotta put a township or city in there or something.
Mr. Avila, you know where you were when this happened? Adrian, come see.
Yeah, Adrian.
All right, so Mr. Sneed will verify that, but on January.
City of Adrian, Judge,
18
thank you.
Okay, January 18 of 25, were you in the city of Adrian in the county of Lenawee, Mr. Avila?
Yes, ma'am.
Or I'm sorry. Do you, let me go back up. I think I asked that wrong. So how do you wish to plead to the charge that on or about January 18th of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense of attempted weapons carrying concealed? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
Right. So other than the agreement that was placed on the record, Mr. Avila, has your attorney promised you any other particular sentence or estimated what any other part of that sentence would be?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
Right. So, Mr. Avila, on or about January 18th of 2025, you were in the city of Adrian in the county of Lenawee?
Yes, ma'am.
All right. And you had a weapon in your vehicle?
Yes, ma'am.
And do you have a concealed pistol license?
Yes, I did. I just
Yeah,
I didn't have it registered at the time. I forgot that it was in there, and I just didn't
So
register it at the
you
time.
have a concealed pistol license now. You didn't at the time, though.
I mean, it was.
You don't have a CCW permit, man.
I did, but it was restricted, I guess. I thought the restriction was lifted off, but I guess I was still 2 months into being restricted. So
I don't know what that means.
No. That my CPO,
Like for me, I have a concealed pistol license that's not restricted, so I can carry it where police officers can carry. So what do you mean by restricted?
it was restricted for like a year because I caught a simple assault a while back.
So your
I thought
concealed pistol license
was restricted,
wasn't
yeah.
valid at
Yes.
the time you had the weapon concealed in your
Yes,
car.
and I forgot the weapon was even in there. I thought I took it in the house. I worked third shift and I worked 12 hours, 6 p.m. to 6 a.m.
Okay,
And I just
hold on.
totally
Okay.
forgot.
Mr. Sneed, are you satisfied with that?
Yes, thank you.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Glazier,
Yes, Your Honor.
Mr. Sneed?
Yes, thank you.
All right, so let me get back there. So we're doing a delayed. So I will accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the agreement, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew plea that was placed on the record. I'm going to refer this matter to the probation department for a pre-sentence investigation, but Miss Adams, can I use July 16 as a sentencing date?
All right, this is August, Judge.
It's a delayed, so I gotta set it out 11 months.
Oh, you put it out a year. Okay, I could say my mind isn't working right. So it was, what was it, July what?
Oh, I'm not asking you yet. Hold on, Miss Adams, can I use July 16?
Judge, I would say Friday, July 17th would be good.
All right, so I'm gonna set this for sentencing on July 17 of 26 at 8:15 in the morning. Do you want to appear via Zoom or in person, Mr. Avila?
Zoom would be fine.
All right, so Mr. Avila, I'm going to put you in a breakout room with Tom Moore here in just a second, and he's going to get your contact, and Mr. Coast. So they're going to get your contact information, and then Mr. Moore will set up a time to meet with you. He'll do a pre-sentence report when you meet with them, be truthful about the offense and the your background, and he'll prepare a pre-sentence report. We'll get that to Mr. Glazier. He'll review that with you. I am going to assess the fines and costs now, Mr. Glazier, because that has to be paid off during that 11 months as part of the requirement. So, Mr. Avila, you are employed? Third
Yes,
shift, you said, right?
Yeah.
All right, so I'm gonna assess $750 in court costs, $130 crime victim rights fee, $68 and state costs. Let's see here. There is let's see, there's no attorney fee. So $750 in court costs, $130 crime victim rate fee, $68 in state costs. There's going to be a supervision fee payable to Darren Coast for pretrial services, not directly to him, but to that department for supervision fees in the amount of $30 a month, $60 if we got to put a tether on you. I don't think we will. I don't see that there's any restitution, Mr. Sneed. So that will have to be paid off during that 11 months. Do you understand that, Mr. Avila?
Yes, ma'am.
All right. And okay, so let me open up that breakout room real quick.
Judge.
Yes.
Do you do the forfeiture now or no?
And the weapon's forfeited, so they already have it. So okay. So Darren Coast, John Glazier, and Tom Moore join that breakout room. All right, we'll give them a moment to get that information. Gotta wait for Mr. Moore to get back, so. So hold on, Miss Underwood. Miss Underwood, are you getting a date on Miss Heimerdinger?
Your Honor, could I talk to her?
Deb, let me bring her in. And then I have, actually Brianna Spiegel in the courtroom too. All right, in the matter of all right, Ms. Heimerdinger, if you could start your video and your audio. All right, Ms. Betts, why don't you come on up? All right, so Ms. Underwood, we're back on the record in the matter of the state of Michigan versus Julia Betts. So you did have a breakout room with Mr. Moore and somebody else. But how do you wish to proceed with Ms. Betts today?
Your Honor, Ms. Betts wishes to plead guilty to the violation, Your Honor, and a sentence. We would waive a PVR in this matter, Your Honor, and the recommendation, I believe, is going to be that Ms. Betts will be returning to recovery court.
Okay, all right. So while I'm waiting for Mr. Moore to come back, in the matter of the people of the state, just have a seat right there. In the matter of the people of the state of Michigan versus Jamie Marie Heimerdinger, I'm going to open up that breakout room. So Ms. Heimerdinger, you and Ms. Underwood can chat real quick. And while I'm waiting for appeal. Mr. Moore, Ms. Underwood is in a breakout room with another person while you guys were there, so
Okay.
for just a minute.
Judge, I don't think there's any pre-trials left, according to my calendar. Just want to confirm.
I don't think so. I think you're done. Let me check.
Okay.
No? Well, wait, why do I have that file? I have a file. I don't know why I have it. Hold on. I don't think there's Gregory Bowers that was set for a pretrial. I don't think we did that one, Mr. Glazier. And then I think we lost Mr. Glazier. No, I think.
Can't wait on him anymore this week.
I think so Miss Adams, I have advice of rights and I have a plea agreement on Bowers. He didn't already plead, did he?
I think that's up for tomorrow, apparently.
Who are we talking about, Judge? Bowers?
Gregory Bowers, 25-22231 FH. I don't have a notice in the files. You're making me yawn, Julia. Sorry.
Judge, it does look like some things are scanned in. There's a plea agreement, but my court's not letting me view those. So let me go to the clerk's office and find them.
Okay. All right, so I have Miss Underwood back. So Miss Betts, why don't you hop back up to the podium? All right, so Miss Underwood, let's go to Miss Betts. So,
Could I ask to go to Miss Heimendinger first? She has some special circumstances that I want to get her off the screen as soon as possible.
oh, okay, so have a seat back now.
I apologize.
All right, well, there she is. All right, so back to Miss Heimerdinger. So, Miss Underwood, how would you like to proceed on behalf of Miss Heimerdinger?
Actually, the way I wanted to proceed has changed, Your Honor. Miss Heimendinger is in the hospital. She literally gave birth to a baby a few hours ago, Your Honor.
Okay, but, okay.
So, I don't think it's appropriate to take a plea this morning. What I would ask is to set this out to that September 17th date. And at that time, this matter should be resolved.
All right, so I will set this out to September 17th at 8:30. You can appear in person, Miss Heimerdinger, or via Zoom. And Miss Underwood, can you do the stip in order to adjourn?
I don't believe we need a stip in order for.
Oh, it's probation. We'll do the notice of hearing. So Miss Heimerdinger, we'll see you back on September 17th at 8:30. Understand you still need to report to probation, all right?
Okay.
If you
I have a
report
question.
Yeah.
I haven't been reporting, so I didn't know that I had to report. Like now.
Yeah, you're still on probation. So your probation officer, Sarah Teskey / Tom Moore. So Mr. Moore, she's still required to report, correct?
Well, that'd be correct. I mean,
Yeah, until your probation is terminated, you have to report because you're here for failure to report. So yeah, you got to report. When would be her next report date, Mr. Moore?
well, I suggest that you give Agent Teskey a call and whatever, let her know what your circumstances are there and what, you know, as far as your hospital stay and whatnot, so you can schedule a day with her.
Okay.
So why don't we tentatively, you know, I'm assuming you're going to get out of the hospital at a normal time here, you know, for a few days. Am I correct?
Yeah.
Okay. So why don't you contact her, but let's on the record, schedule her to report next Tuesday. And if there's an issue with that, you can discuss it with Ms. Teskey, okay?
Okay, so Ms.
Okay,
Heimerdinger,
sounds
you
good.
need to reach out to Ms. Teskey, okay?
Okay, I will do.
All right, thank you.
All right, thank you. Have a good day.
You too. Bye.
Bye-bye.
All right, Ms. Betts, let's go again. She's been up and down, up and down. All right, so we are back on the record with Ms. Betts. Ms. Underwood, if I remember correctly, you said Ms. Betts was going to plead and we would proceed to sentencing today.
That's correct, Your Honor.
All right, let me find her in my paperwork. There she is. All right, so Ms. Betts, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so we have 3 files on 23-21519FH. The allegation is that she violated the terms of her probation and that she tested positive on a PBT for 0.106 BAC on July 20th of 2025. The maximum penalty on that offense could be up to 14 years in prison for that violation. And then on file number 23-21264FH, same allegation that on July 20th, you submitted to a PBT test and tested positive at the level of 0.106 BAC. And then on the last file, I'm assuming it's the same thing. And on that charge, you're on probation for attempted possession of methamphetamine, which is a 5-year felony. And Mr. Moore, the other probation officers are really nice and they put the max penalty in there, so I have to dig for it. I don't know it, but that's just them. So, and then on file number 22-21100FH, same allegation, you submitted to a PBT and tested positive, and it was 0.106%, and that's for a 4-year larceny in a building. So the maximum penalty on that offense could be up to 4 years in prison. So Ms. Betts, you have a choice of pleading today, and it's my understanding you're going to enter a plea of guilty to these violation of probations.
Yes.
Now, you were in a breakout room with your attorney and also Mr. Moore. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes.
Did I swear her in, Joanne? Oh, she's been up and down.
No.
No, I didn't
Yes,
know.
Yes, you did. Jim.
I did,
You
okay.
You did.
So, do you understand that you have a right to contest this violation of probation charge and to have a trial on it? Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial.
Yeah.
You understand all of that? You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
How do you plead on each of these files to the charge that you violated the terms of your probation by consuming alcohol and testing at a level of 0.106%?
Yeah.
All right. Do you understand by pleading guilty, you'll be giving up your right to a trial, as I've already explained to you?
Yes.
Has anything been promised you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
All right. So Ms. Betts, you were placed on probation. One of the terms of your probation is you are not to consume any alcohol, correct?
Yes.
And on July 20th of 2025, did you consume alcohol?
Yes.
What'd you have?
2 twisted teas and 2 beers.
Okay. All right. And you knew that was in violation of your probation.
Yes.
Would you agree that the PBT that was administered showed that your blood alcohol content was about 0.106?
Yes.
Okay. Accept the plea. It has been given understandably, voluntarily, and accurately. She has full knowledge of her rights. She does have competent counsel. So you're waiving your right to a probation violation report, correct?
Yes.
So I could set this out a week and then Mr. Moore will do a report and interview you. But I think Ms. Underwood said you were just going to proceed to sentencing today.
Yeah.
So you want to waive your right to a probation violation report?
Yes.
All right, Mr. Moore, could you make a recommendation, please?
Yeah, it would be recommended that she be continued in recovery court and get credit for time served, which is 1 day, 2 days.
From 1 day or 2?
2, well, rest and, well, she was seen the same day. You give her 1 day.
Okay. All right. Is there anything you want to say on behalf of Ms. Betts, Ms. Underwood?
Just that I think the resolution is appropriate, Your Honor.
And Ms. Betts, anything you want to say?
No, thank you.
Ms. Betts, you have worked incredibly hard in our recovery court program and you have excelled. and I'm super proud of you every time I see you. But you're not at a place in your life where you can have a normal day and have a beer, right? Okay, and you have a lot to lose now. You built up a really good life. So we can't do this anymore. All right, Miss Adams, can I get an advice of rights from Miss Betts? Do you have one already? Probably not.
The same ones. Same ones.
Oh, no, that's only for felony. Can I get an advice of appellate rights for Miss Betts, Miss Adams on both files? So Miss Betts, it's sent to the court. You'll be continued on probation in the recovery court. I'll give you credit for 1 day already served. We're going to get your notice of right to appellate review. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Have a seat. When we bring it in, you can just initial and date 1 copy for your records, okay? All right, thank you. All right, so Ms. Underwood, I have Ms. Eagle, so why don't you come on up? Miss Underwood, are you able to send Mr. Glazier, or Miss Adams, were you able to find anything out about Bowers?
Yeah, the clerk's office was hunting it down for us.
So it
still
was
waiting
for
on-
today?
I don't know. It won't let me pull up documents, but they are scanned in.
Okay, okay. All right, so this is in the matter of the people of the state of Michigan versus Brianna Lynn Spiegel. File number 22-20816FH, 24-21737FH, and 24-21738FH. Brenda Underwood appearing on behalf of Ms. Spiegel. So
Have I been appointed on this, Your Honor?
Oh, no, I guess not. So Ms. Spiegel, did you receive a copy of the request and summons for probation violation?
Yes.
Okay, so do you understand the allegations on it is that you failed to report on July 15 and July 22nd of 25, that you failed to test as required, and you failed the test from July 6th through July 15 of 25, and that you did test positive for the controlled substance MDMA, fentanyl, methadone, and amphetamines on July 20th of 2025, and that is on each of your files. Do you understand that?
Yeah.
Okay. Now, Ms. Spiegel, you do have the right to have a court-appointed attorney to represent you. You want an attorney appointed to represent you. She's here. Okay, so my bailiff's gonna take you out to the hallway and hook you up on that podium, okay? And then when you zoom into mine, I'm gonna put you guys in breakout room, okay? Take that Kleenex with you. All right. So,
Your Honor, if you could put me in that breakout room and I can leave so she can talk to her, but just so I can update Ms. Underwood on the situation.
sure.
Thank you.
All right, so Mr. Moore, are you and Ms. Teskey both doing recovery court now?
No, I'm just easing her back into it.
Wow, you can stay too, we like you. All right. Okay, go ahead and join the breakout room. Thank you. Deputy Lucy. So Ms. Beth, just go ahead and initial that top copy, all right? Thank you. Julie. Oh, thank you so much. All right. Yeah, come back in. All right. All right, so Miss Underwood, we are back with Miss Spiegel. So Miss Underwood, did you have an opportunity to speak with your client?
I did. Thank you.
And Mr. Moore, thank you for providing updates, but Miss Underwood, how do you want to proceed? Miss Spiegel, you had a chance to speak with Mr. Moore and Miss Underwood.
Yeah.
Are you
Your Honor,
satisfied
just for
with
the
Miss?
record.
Hold on. Are you satisfied with Miss Underwood as your attorney and the advice that she gave you? All right, Miss Underwood, how would you like to proceed?
Your Honor, for the record, I did receive the documents and have reviewed them. I also had the benefit of our talk with Mr. Moore, Your Honor, who informs me that the plan going forward for Miss Spiegel is to engage her in treatment and keep her in recovery court. And hopefully that will be all that's necessary. But he would like to put the sentencing out about a month to make sure that Miss Spiegel is continuing on the trend she has been on, Your Honor. And so Miss Spiegel is going to plead guilty today with the probable sentencing agreement of no further jail time and continue in recovery court.
So raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so Ms. Spiegel, you've heard the statement of your attorney. Is it your intention today to plead guilty to the violation of probation?
Yes.
All right, and you understand we'll be setting sentencing out about a month so that you can get heavily back into treatment?
Yes.
Okay, so Ms. Spiegel, I'm gonna go through your rights with you. So do you understand that you do have a right to contest this violation of probation charge and to have a trial on it?
Yeah.
All right, speak up a little bit for
Yeah.
me. Okay, do you understand that throughout this trial, you will be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
How do you plead to the charge that you violated the terms of your probations by failing to report for probation on July 15 and July 22nd of 2025? Guilty or not guilty?
Guilty.
And how do you plead to the charge that you failed to comply with the requirement of drug testing by failing to test on July 6th through July 15 of 25?
Guilty.
And how do you plead to the charge that you tested positive for the controlled substance MDMA? I don't even know what that is. What is that? Ecstasy, fentanyl, methadone, and amphetamines on July 20th of 2025.
Guilty.
All right. And do you understand by pleading guilty, you'll be given up a right to a trial? Has everyone explained to you?
No.
Has anything been promised you to get you to plead guilty?
No.
Anybody threatened you in any way to get you to plead guilty?
No.
Has anyone, if I accept the plea, you'll be giving up any and all claims. What is it? I don't have attorneys and I don't have a notice. This has no attorneys present. And
So you're looking for the notice.
This is a
and
probation
Mr. Sneed
violation.
doesn't believe it's separate today. Okay, okay, she squirreled me. She was over there like making rustling noises, so, all right, okay. Is it your own choice to plead guilty?
Yes.
All right, so Ms. Spiegel, you're on probation, and one of your terms of probation is that you are to report as required to the probation department, right?
Yes.
Did you fail to report on July 15 and July 22nd?
Yes.
And then you're supposed to drug test, and did you fail to test from July 6th through July 15?
Yes.
And you knew you were supposed to.
Yeah.
And then when you did test on July 20th, you were positive for ecstasy, which is MDMA, fentanyl, methadone, and amphetamines. Is that correct?
Yes.
All right. And that's why you didn't report, because you relapsed. Okay. Did accept the plea. It has been given understandably, voluntarily, and accurately. She has full knowledge of her rights. She has competent counsel. So I'm going to refer this matter for a pre-sentence report. Ms. Adams, I'm looking for a sentencing date around September 18, 19, 25, or 26. She went down the hall. Becky, are you in your office?
Yes, Judge.
Oh, I need a sentencing date from Ms. Spiegel, but I need it for like September 18, 19, 25, or 26. And a notice of hearing for.
We could do September 19th at 8 a.m.
All right, so I'm gonna set it for sentencing September 19th at 8 a.m. Ms. Underwood, are you available?
That's fine.
All right, so you're gonna have to report and have an updated probation violation report done. We'll get a copy to Ms. Underwood. She'll review that with you before sentencing.
Okay.
So what happened? Because you're like doing a great job. So what happened? If you want to talk about it, if you don't, you can talk to Teresa or somebody else about it.
Oh, I have been.
Okay, but don't do this, you know, but you're gonna be okay. You can get past this and just follow the programming. And if you need anything, obviously we're always here, right? Okay, so we'll get you a notice of hearing and then you're all set. Mr. Moore, do you want her to come over today?
I seen her yesterday and she's gonna come. She's coming next Tuesday and she's engaging in everything she's supposed to do from now till then.
Okay, so we're closed evidently next Tuesday afternoon, so it'll have to be in the morning.
Yep.
So, okay, have a seat. We'll get you a notice of hearing and we'll see you back then. So, Miss Adams, do we know if Bowers was set for today or no?
Judge, the last hearing, the public defender was supposed to do a stip and there's no stip.
Okay, so in the matter of the people, Miss Underwood, if you can hang on just a moment. We had a case on the docket that was in the matter of the people of the state of Michigan versus Gregory Allen Bowers. File number 25-22231FH. It's on page 4 of my docket, Miss Underwood. The last time we were here, we adjourned it to today, but somehow, and it doesn't happen very often at all, a stip and order wasn't done, so I don't know that Mr. Bowers even had notice. So could you let Mr. Glazer's assistant know we need a stip and order to adjourn? And we're going to set it over to September 17 at 8:30 in the morning. All right?
Is that Mr. Glazer's case, Your Honor?
Yes, ma'am. Yep.
Okay, and the first name on the file?
Gregory, Gregroy, Bowers, Bowers, file
Thank you.
number 25-22231.
Thank you, Your Honor.
Yep, thank you, and I do believe I got nobody else.
Well,
All right.
can I ask what happened on Mr. Vetter, Mr. Rosenberg, and Mr. Norman?
Mr. Norman failed to appear and I issued a bench warrant for 25,000 cash. Mr. Collins failed to appear and I issued a bench warrant with bond of 25,000 cash on each file. And Mr. Rosenberg retained David Goldstein. What was the other one?
Vetter.
Vetter was dismissed.
Vetter was dismissed?
Yeah.
Great.
Yep.
Thank you, Your Honor.
All right, that concludes our criminal docket. Thanks, everybody.
Bye-bye.
Bye. So, in the matter of Alyssa Wilnow? No. Alyssa Wilnow versus Faith Miller. You can check the hall. All right, you need to break the stage before we go on. You do?
No, I'm fine.
No?
No, I'm fine. Thank you.
Okay, so